realestate.com podcast with your host, DJ Van Kuren. He's from the Arsenal Family Office. Each podcast is about real estate-related topics specifically for family offices. Now your host, DJ Van Kuren.
Hi, thank you, and welcome to the U.S. Family Office Real Estate Podcast. Today we've got a very interesting topic that we're going to be talking about. Today we've got Bryan, Mick, and Brad Updike with Mick Law, and we're going to be talking about conservation easements and how those can be beneficial for family offices from an investment perspective. So first I'd like to welcome Bryan. Brad, welcome to the show.
DJ, thanks for having us.
So first off, why don't you tell me a little bit about your firm, background on your firm, what you guys do, and then we'll get right here into the topic.
Sure. So Mick Law is a specialty firm. We're based in Omaha, Nebraska. For the last 13 years, we've been exclusively representing broker-dealers, registered investment advisors, family offices, and some small institutional pension-type funds. Our focus is due diligence on private or non-traded securities transactions. We have a significant presence in all aspects of real estate. We have a robust energy practice. We also review private equity, hedge funds, other products for a mixture of investment industry clients.
Great. Well, I'll tell you, about three to 4 months ago, this word conservation easement came up, and it happened to be with a developer out of the Midwest, and he started talking to me about this, and it was really the first time that I had heard about this topic, and I think that's the case for many, many people. And then about a month after that, we were having a conversation, and you had brought up about this paper that you'd wrote that was published about conservation easements, and immediately I thought it would be a great topic to go into much more detail and to educate those that are unaware of conservation easements and how they work. So why don't we start, and let's start with what is a conservation easement?
Conservation easement, this is Brad Updike with Mick & Associates. I'm an attorney here, and I've been with Mick & Associates for 10 years. But to answer your question, a conservation easement is a legally enforceable restriction on the fee simple estate that substantially prohibits the commercialization and development of the real estate forever. The restrictions are legally put in place through an easement deed that's filed in the county property records where the property is located. The restrictions are enforced by the easement holder, which is usually a land trust, but it can also be a governmental unit.
So let's back up here a little bit. So if we were to break it down from a fundamental perspective, this would pertain to if a family, for example, had a good amount of real estate or land that they wanted to do something other than develop it. Is that correct?
That is correct. Yeah, this is
okay.
Generally land that has significant conservation values. In many cases, there will be like endangered like animals or plants that are on the property, or in some cases it's just basically environmentally beautiful land that's viewable to the public.
Well, and DJ, I need to clarify. There's really two separate situations because you mentioned obviously if there's a family office that controls recreational or developable real estate that might want to take direct tax advantage of a conservation easement. That's one scenario. The other scenario with which we are most familiar is a family office investing or co-investing in a transaction that is syndicated. The transaction itself would have three potential investment thesis, if you will. The first is buy and hold the property for future appreciation or disposition. The second would be commercial development of the property. And the third would be placing a permanent conservation easement on the property. And 2 and 3 tie together in the sense that if the property is acquired, it meets the requirements to qualify as a conservable property, and an easement is granted to a qualified organization, you get a charitable contribution deduction under Section 170H of the Internal Revenue Code equal to the present value of a commercial development, or the difference between the present value of a commercial development and the restrictive use that prohibits that development. That's where the real power or oomph is, if you will, in participating in a syndicated investment that would have development possibilities, but the investors choose to place a conservation easement on the property.
Yeah, it's special property, though, in both cases, regardless whether we're talking about a syndicated transaction or just an easement where a family just wants to conserve property. It's going to be property that has significant conservation values and generally also property that could be commercialized or developed.
All right, so let's say that I've got 100 acres of land, right? And I say, I'm not going to be, I don't want to, I possibly could develop it, right? So I could do a master plan and commercial buildings, etc. But I choose not to. Does it matter the type of property that you can turn into a conservation easement, or can you do any kind of, can it be any piece of land?
It could be, that at least has to, I would say at a minimum, it has to have certain conservation values that are recognizable in the Treasury regulations. It can't just be, I think, any 10 acres of just ordinary like forest. It has to be acreage that meets one of the four criteria, which would include it would be properties that significant animals or plant habitats live on. As far as in terms of significant, that's generally defined as a endangered or threatened species of plants or animals. Also,
open space
qualification. If you have 100 or more acres of very quality timberland that has scenic views, scenic beauty, that would also qualify. There's also a historical property exception if you have like open space area that's viewable, that's also got there's been historic activity in the past, significant historic activity such as like maybe a Civil War battlefield or Revolutionary War battlefield that would qualify. There's also a historic build exception too.
And most of the, DJ, to clarify here, most of the syndicated transactions that we see are near population centers, near significant vacation and second home destination areas, a lot in the southeast. And just conceptually, the reason for that is for the conservation easement charitable deduction to be robust, it has to be there has to be economic substance to the transaction. So you need to be able to legitimately develop that property into apartments, condominiums, multi-tenant retail, whatever the development plan may include. If you have 1,000 acres in eastern Wyoming, you can still obviously place a conservation easement on the property to protect, natural brown trout or the sage grouse or some other endangered or protected animal in Wyoming, but you won't get the significant conservation contribution, because only reasonably could you take maybe 1,000 acres and develop that into 40-acre ranchettes with a sales absorption of, potentially 8, 10, 12 years, because you don't have the depth of buyers for such a property. So that's why you see on the syndicated side, most of these projects are near very large population centers or very popular vacation second home destinations.
But yeah, from a foundational perspective, though, we're not talking about 5 to 10 acres of ordinary forest land. Generally, the properties that we see placed in these easements, it's 100 acres plus. 100 acres to thousands of acres of quality timberland, forested area that's contributing to the scenic landscape of a very vast area.
Okay, so let's say that I have that 100 acres that I spoke about, and I have the ability to develop on it, and let's say it's a $100 million development. How would something like that be syndicated, and how could the family office benefit from something like that if it wasn't their piece of land, but I came to them and I said, okay, here's $100 million of development, it's 100 acres. What would that look like on the syndication side? How much of that would be syndicated, and what would be the benefit to the family office for participating in that syndication?
I think if you have, let's say you have 100 acres, okay?
Yep.
And let's say that property is worth $2,000 an acre. Mm-hmm. So you're at $200,000, okay?
Yep.
And then you create a development plan, and whether it's 10 or 100, that seems a little egregious, but we'll call it a $10 million development. Now that's gross development value. So what you do is you would get a qualified appraiser involved, and from our analysis of various transactions, we want to make sure that appraiser is MAI certified, Master Appraisal Institute appraiser, preferably has undergone the MAI training, which is a multi-day, very intensive appraisal training on valuing conservation easements.
That he's not being targeted by the IRS.
And we want to understand his prior transactional work and whether there may be others under audit. And then you take that $10 million gross development, you have a budget and a pro forma that includes building the infrastructure, streets, utilities, grading, et cetera, and you have a market research of that development supporting a certain sales price for finished lots or built condos or whatever the product may be. You have a pro forma that includes a reasonable construction CO, certificate of occupancy completion, and a sellout period over 6, 7, 8 years. And then you do a discounted cash flow analysis to determine the present value of that development. So if the present value of that gross development is $5 million, essentially, and this is simplistic terms, but essentially the differential between that present value development of $5 million and the $200,000 or $4.8 million would be considered a charitable deduction, provided that all the other structural requirements are met.
And while you're you're putting together your development due diligence file to support your development option, you're also going to be undertaking efforts to zone the property and get it entitled, because when a property is zoned and properly entitled, I think you have a stronger argument for the highest and best use being being a commercial property.
So if you have that, $4.8 million in this example, how does that equate for the family office, and is that what would be syndicated, the $4.8 million, or would it be less than that? Or more
no, that if the family office could control and own the property and jump through all the structural and analytical hoops, if you will, the $4.8 million charitable deduction would be available to the family office. Obviously, in the syndicated world, and we have advisors and broker-dealers who, place particular restrictions relative to clients that can utilize the charitable contribution. A number of them require that the client be in the highest marginal tax rate. If you have a family office, the most powerful structure, of course, would be an individual or subchapter S or LLC, so that the contribution could flow through to the individuals. Brad can address the limits on AGI and the carry forward involved with that.
Sure. For individuals, the deduction, it's generally limited to 50% of the investor's AGI for a tax year. And there's also a 15-year carry forward that applies as well. So if you have an investor that gets a pass-through deduction of $250,000, but let's say their AGI is such where they can only use $150,000 of the $250,000 deduction. That means that the remaining $100,000 of the deduction that can be used and carry forward for up to 15 years. In many cases where we had conversations with syndicators that have offered this this opportunity to retail investors, our understanding is usually 2 to 4 years is how long the investment. How long?
So are you maxed out at $250,000 a year? So if somebody was making $2 or $3 million a year, then they would only be able to deduct $250,000 per year. Is that correct?
No, that's just an example. Actually, it's 50% of the AGI. I just used $250,000 as an example of a deduction.
Okay, I see.
Yeah, no, there's no limitation other than the 50% of AGI. So if somebody made $2 million in a calendar year, the charitable deduction would be $1 million in that calendar year. And then, obviously the economic return is based on, 39.6 Fed and, assume 6 or 7% state and local tax rate. You can apply that 45% to your charitable deduction, and obviously the economic value of that deduction is $450,000.
Sure. One thing I would want to clarify, because we've talked about syndications and how these syndicated opportunities, come up in the retail channel. Generally, what we have is there's a network of about 20 or so program syndicators or sponsors that are offering these real estate investment programs that utilize conservation as a part of the business plan. These syndicators know CPAs, they know attorneys. It's generally well understood who they are. So on a day-to-day basis, these program sponsors, they're being approached by landowners that have property. In a lot of cases, these landowners, they think that their properties would be good for these good investments for these programs. They know that the properties have conservation value and also can be potentially commercialized as developable properties. They enter into negotiations with the program sponsors. The program sponsors, syndicators, as a part of their due diligence, they get an appraiser involved in their evaluation process. The appraiser will give them a determination of what is a defensible fair market value of the property. And then it's a negotiation, and the way one syndicator's explained to me, it's a little bit like Pawn Stars. The syndicators are going to negotiate a price with the property owners that will facilitate and provide for a competitive income tax deduction. So because the highest and best use fair market value of a property might be like $15 million, that's not what the syndicators are going to negotiate the acquisition price for. It's going to be a lot. I guess Pawn Stars would be a good maybe example of how that negotiation process works. And in a lot of cases, if they negotiate a $2 or $3 million purchase price, that's a heck of a lot more than a lot of these property owners thought they would get. In many cases, these property owners, they have an idea, a vague idea that their property might be commercialable, but they don't know what the value is. So a lot of times, just getting, 20 to 25% of that defensible highest and best use fair market value, they're willing to take that based on their financial circumstances.
Well, we're gonna take a quick break, and then we're gonna be back to talk more about conservation easements. There's a couple questions that I have that I want to address after the break, and then I also want to find out about some of the pitfalls that family offices need to be aware of. So we'll be right back in a minute.
Hi, this is Jim Freed, the host of Freed on Business on 880 AM The Biz in Miami, and you're listening to the U.S. Family Office Realestate.com podcast. The podcast provides you real estate information designed specifically for family offices. Make sure you check out USFamilyOfficeRealestate.com for educational information for family offices, including white papers, fact sheets, videos, and podcasts. You'll also find information on specific markets and assets, real estate cycles, tax-efficient real estate investing ideas, and much, much more. That's USFamilyOfficeRealestate.com. Information for family offices by a family office.
Welcome back to U.S. Family Office Realestate.com podcast. Today we've got Bryan Mick and Brad Updike with Mick and Associates. We're talking about conservation easements and family offices and how they can benefit from them and what they are and the different strategies. So I want to get back to a quick question here. So you can deduct up to 50% of your AGI. So in that one example that you were talking about, Bryan, you were saying on that, if somebody made $2 million, then you've got that $1 million to deduction, and you take in consideration the taxes. In order to receive that $4.8 million deduction, which you can do over 15 years, how much would something like that cost for a family office to purchase that $4.8 million roughly?
I would say if your deduction is 4.8 in a syndicated transaction, your investment in the LLC that owns the real estate would be approximately $1.2 million.
Okay, so it's about 25%.
Yeah, and we see generally a charitable deduction allocated at 4 to 4.5 times what the investment amount may be. There are obviously transactions outside of that range, but generally speaking, that's what we see in the offerings that we analyze.
You got that 25% that was just talked about by Bryan. That's going to generate a return on investment ROI of roughly 1.5 to 2 dollars for every dollar invested, and you're going to realize that generally over the first 2 to 5 years of the holding period.
Right.
That's
so then what are some of the IRRs then that you've seen on some of these syndicated programs from a return Are they claiming that you should see 20 to 25% return on your investment? Is it higher? Is it lower? I mean, is there a typical number that they associate that with?
Yeah, it's generally quite higher. And remember, the IRS is attacking a number of these transactions based on various components, one of which a primary element is obviously the appraised value and the value then concurrently of the conservation or the reduction in value of the ground subject to the conservation easement. But the math, generally speaking, if I invest in a transaction that has a legitimate opportunity to pursue any of those three legs of the stool that I talked about before. Number one, being invest, hold for appreciation or later disposition. Number two, being a legitimate commercial development with economic substance. And number three, being the conservation easement option. If option three is chosen and I invest $100,000, I should be able to receive, if all of the members of the LLC vote to conserve the property, a charitable deduction of $400,000. So if my charitable deduction is $400,000 and I'm at the highest marginal combined federal and state tax rate for easy math, let's call it 45%. So my net value of that charitable contribution is $180,000, and I've made $100,000 investment. So depending on the timing, of course, the tax year in which the charitable deduction is claimed, and the filing time of the investor's tax return, whether it be April 15th or extended, at a minimum, my IRR would be 80%.
Mm-hmm. Right. So how long does it – so to me, with what you're saying, I see a couple of different opportunities here on the family office side. One is that if they have land that does qualify under this conservation easement, that they could end up taking that whole deduction themselves, which could be considerable, or it would be investing into conservation easements that others have so that they could get those deductions and, obviously a return on their investment. How long does it take? I'm sorry?
That's very well stated. Those are the two succinct opportunities for family offices.
Okay, great. So let's say a family has a piece of land and they start this whole process. They identify, yes, we think that there's something there for a conservation easement. What's the typical time from start to finish that it takes to go through the whole approval process?
Well, I would say at an estimate, year and a half, 2 years, you have to do the you have to first select a charitable organization, a land trust, or as Brad said, even a governmental entity. We would prefer, frankly, a land trust or other charitable 501c3 qualified organization.
Might have zoning.
So first off, you have to go through the analysis of who your easement donee is going to be, and that's not just simply picking somebody off the internet and saying, oh yeah, they're interested in conserving the Rocky Mountain elk. I want to go with these guys. You have to look at the experience of that organization in receiving, managing, and enhancing the conservation value of the property going forward. You have to look at the financial wherewithal of that organization. What do they have in terms of working capital? How have they done from a cash flow perspective the last several years? You don't want to get involved in a charitable organization that has a precarious financial situation. Then you have to move on and look at the property and see whether the property can reasonably be zoned for your proposed purpose. And at that point, you need to be getting a consultant or a developer involved to assess the highest and best use. It's starting to tie into the appraisal, which will come later, but the highest and best use for a financial return on that asset based on a proposed development. And then you're going to want to get a qualified appraiser involved.
You may have a holding period issue because in order to get a fair market value charitable tax deduction, you actually have to have held the property as a capital investment for a minimum of 12 months. So if this is property that you just acquired, you've got a holding period issue to consider.
You may get a biology consultant, depending on the land trust or charitable organization that you work with. They may have somebody in-house. They may work with folks on a consulting basis. You need a consulting biologist to assess the conservation value of the property from a qualification perspective. Brad talked about that a little bit earlier. And then, you know, if you want to strengthen the possibility of winning, if you will, in an audit situation with the IRS, you may need to go so far as putting out a request for proposal for financing for the project, receiving a term sheet or a commitment letter from a bank to do a construction mini-perm loan. Once you get all those pieces in place, zoning, permitting, potentially getting a loan commitment, some of those things, you choose your qualified organization, you have a consulting biologist, and you're working with a developer, then you're really at a point where you can negotiate the final form of easement and get that recorded. And there are significant timing issues relative to not only the final date of the appraisal, but the recording of the easement and some other kind of technical stuff.
So yeah, all of that can take more than 1 year.
So from the, obviously there's a lot of moving parts and a lot of things that you have to do. So if you're a family office and you're either going to utilize it yourself or you're going to invest in some of these syndications for the tax benefits, what do you need to look out for? You know, what are the possible risks? And, you know, because somebody could end up knocking on their door one day and say, hey, I've got a conservation easement, here you go, you know, invest into this, and this is how much it is. So what should they look for from you know, in order to mitigate the risk and to make sure that it's a legitimate a conservation easement? Because you had mentioned a bunch are getting challenged or have been challenged. So what should they look for?
Based on our personal research and knowledge of this area, I would venture to say that there's probably 20 or 25 companies or people that are syndicating investment programs in this asset class. The thing that you have to be concerned about is whether the opportunity is structured as a bona fide real estate investment program. Does it have a developable piece of property? Is the development plan comprehensive and well-defined within the offering documents? Also, if this is a legitimate real estate investment program, the features, the investment rights of the partnership, they have to be comparable, or they need to mirror other real estate investment programs out there. There needs to be reasonable manager removal rights. There needs to be proportional sharing of deductions in income based upon the percentage interest that the investor acquired. There needs to be no put options. The holding period in the partnership, it needs to be undeterminable. There can be no unreasonable reversions in favor of the program sponsor once the investors have enjoyed their tax deduction. So it needs to be structured as a bona fide investment program, because if it's not, all you're doing is you're just selling an income tax deduction, and that's not allowed.
Right. And I think another area is, and Brad talked about some of the technical requirements, this thing needs to look and feel and act and sound like a real estate deal. And Brad went through a number of the features that we would analyze if we were looking at a straight commercial real estate investment deal. The other thing is to review the website of the company that you are thinking about dealing with. In a lot of cases, they will boldly proclaim the tax deduction on their website. They're in the business of selling tax deductions, which is impermissible. And maybe, just a simple Google search of the people and the company and the people involved, you might end up with some prior audit transactions or litigation involving that particular sponsor. But it's a very technical analysis in terms of the structure and the compliance with the program of the various Treasury regulations surrounding the charitable contribution.
There also needs to be a competent and experienced person that's going to lead the development, assuming the investors were to choose to develop the property. Because if you don't have that, really your development option's not real. So basically, in other words, you're just selling a tax deduction if there isn't some experienced and reputable developer that's involved in this that'll take that responsibility on.
Yeah, but what happens then what happens if you find a developer to do this, and they're lined up to develop it out, and then it's ultimately going to be used for this conservation easement? Doesn't that put the developer in a bind in some way, or do they become part of the deal? How does that usually work?
What we see is some sort of a development termination fee that compensates the developer for original land planning, negotiation with the local zoning, preparing the site plan, the plats, negotiating with the lenders, everything that the developer does, acquisition and pre-development activities, so that the developer is compensated for the work done to date. And it may be as a percentage of the estimated cash flows or a percentage of the final market value of the development. It comes in different forms, but that is, if this is an appropriate, legitimate deal, that should be handled up front.
Right, yeah, and it could be, again, the developer's compensation piece in that. I've also seen it structured as flat fees where they just get basically a termination fee. It's like a flat fee of $250,000 or maybe $300,000 that compensates them for their time and effort in putting the development plan together. Or in some cases it might be based on a small percentage of the net present value of what they would have earned pro forma had the development gone forward.
Got it. Okay, a couple more questions here. So are there companies, let's say you've got a family office, they've got a considerable amount of land, they want to look to utilize this strategy. Are there companies that will do everything from A to Z, or is it something that they would have to spearhead and put together all the different components? So find a developer, make sure the models are ran, identify the appraiser, make sure that the conservation, the group that you're going to be giving it to identify that. So do they have to do all of that themselves, or are there actually companies that will do everything from A to Z?
There are companies that'll help them do it. I think it's very reputable companies. There are a couple of law firms that are very experienced in conservation easement planning, like Baker Donaldson out of Birmingham, Alabama would be one example of a number. Also, there are consulting firms that will help walk people through the process too. Make all the appropriate connections and valuation structure, et cetera. So the short answer is yes, there are A to Z opportunities if a family office with ground that may be appropriate for conservation easement, if they just want to
turn it over to somebody to spearhead all of the development and ensure that the moving parts are all covered, that's very possible.
All right, and what happens if I'm sorry?
You could also work with a program syndicator too, if you had a piece of property and you thought that you might want to put that in a syndication. There are probably a handful of program sponsors that we know that would work with a landowner in that situation.
Okay, and if a family office wants to, let's say they don't have the land, but they want to utilize some of the tax benefits from some of these conservation easement opportunities, how do they find those opportunities?
Well, the easiest answer, frankly, is to call us, because we've seen 7 or 8 of these sponsors of these programs, and they range from high quality to scam. So the reality is, if your folks are interested in pursuing that opportunity from an investment perspective, the easiest thing to do is to hit our website, give us a call, and we will not only provide educational materials to the family office on the history of conservation easements, all the structure, the tax issues, etc., but we will also be able to point them in the direction of the program sponsors that are of the highest caliber in the asset class.
You led me right into my last question. And if there's a family that wants to go down the road themselves with some of their property, would you be able to help them as well?
You bet. Yeah, we'll be able to kind of quarterback that and get them to the right people.
Perfect. Because that was my last question, actually, Bryan, is that how can Mick and Associates help families in this area? So you had mentioned go to your website and whatnot. Could you provide that information, your contact information, including your website?
Sure. The website is www.micklaw, MICKLAW, P as in Peter, C as in Charlie.com, micklawpc.com. My direct dial number is 402-275-1880. The email is bmick, B-M-I-C-K, again at micklawpc.com. And I want to just tell you, DJ, we appreciate the opportunity today. We see a lot of different private Reg D non-traded deals in all different asset classes. We think the conservation easements, again, if done properly, and are involved as one of 3 decision-making trees in a real estate development, can be a very powerful tax tool for higher income individuals.
Yeah, I think that this is an area, like I said, that I just became aware of a number of months back, and I think there's a lot of families and family offices and CIOs of these family offices that can really benefit from understanding about these conservation easements and the benefits, like you said, for not only from a tax perspective, but maybe some property that they have and trying to decide what to do with that property and what type of solution. So this information is absolutely fantastic. I'm glad that you guys were able to take some time to discuss this, and so I wanted to thank you guys for going over this information, and I do encourage anyone listening to this podcast to contact Bryan or Brad, for more information. So today we had Bryan Mick and Brad Updike from Mick Law and talking about conservation easements and for family offices. And here at U.S. Family Office RealEstate.com, we're always trying to find some ideas and educational information that family offices can benefit from. And today is a prime example of one of those that I think will be very, very beneficial. Bryan, Brad, I'd like to thank you for your time today and for going over all this information.
Thanks, DJ. We appreciate it. Have a great day.
Take care. Yep, bye-bye.